Draw blood on the walls.
That's back when we got away with it.
Well, good evening, everybody, and since this is the night where the board will choose its various positions, I'll start the meeting off and ask you all to please stand for the pledge of allegiance.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
First on our agenda, we have our board attorney, Mark Samaruga, from the law firm of Coleman and Conley.
Oh, close. Sounds right.
And Mark is going to talk to us about new board orientation and the role of the Board of Education.
First of all, I hate to kill more trees, but this may help. I have copies for those who are not here. I just want to say one thing, first of all. I'm amazed by the commitment you all folks give. For example, there'll be meetings where maybe when you're a lawyer for a school district, it's 2 or 3 in the morning, you're sitting there advising the board. But you realize one thing, when I'm there, I'm being paid to be there. You're giving your time to do all this. I have to just, again, bow and congratulate all the time you give for this task. And I really do appreciate all the work you do here. It is a lot of work. I mean, for example, I have enough trouble during my day taking care of my day job. George having to speak with me all the time on these issues must be incredibly difficult. So we're all here. Let me just show you the prop. These are Connecticut's education laws. These say a small formation. This is a small formation. There's no way this gives everyone one thing. It's almost impossible for a Board of Education to have, I assume, this all memorized. You have a lot on your plate. The most important thing is the broad parameters. Let me just tell you what the broad parameters of the Board of Education. Let's imagine the Board of Education one night was flat out. You are no longer a public Board of Education. Or what your title be called a Board of Directors. And that's the way to kind of think of your position, as if you are board of directors of a corporation. In fact, your main goal is policy setting goals, and then holding people accountable to meet those goals. The superintendent of schools, actually by law, is referred to as the chief executive officer of the board. You don't even have to worry about the fiction of private life. So in some ways, the model does serve. Another example to use would be this. I'm a lawyer. I have cases I try before a court. And you have a judge who spent many years being trained in law, practicing law, and has gotten to the position where he is. But at a trial, you have jurors. Jurors are not gone to law school, most of them. Most of them have the same training. However, the jurors have an important responsibility. Actually, the jurors have the final call in those cases. Similarly, here you have Board of Education members. You have the final call on many issues where you have someone, Jody, it's almost akin to being a judge. You've gone through many years of life and education to get where you are. And that's kind of the balance you have here between the Board of Education and the superintendent of schools. The board is responsible for setting the policy. The board is responsible for adopting the policy. And school administration is responsible for administering the policy, carrying out the decisions. And again, the superintendent of schools at the end is evaluated by the Board of Education. So that sort of checks and balances circumstances. You're first among equals as board members. However, the fact is the board chairperson does get certain additional obligations and responsibilities and rights you do either way. For example, oftentimes when the Board of Education needs to consult its legal counsel, the request will come from the Board of Education chair. Usually there may be additional requests for information that can be made as a Board of Education chair that they can make. So there are some additional policies. In addition, I imagine, if I'm wrong on this, whether the policy, oftentimes the Board of Education chair and superintendent of schools work together on developing an agenda. So that's an additional responsibility that's given to the board. Now, in your school system, you have teachers. And I believe the hiring of them is probably delegated to the superintendent of schools. I believe that's what happens in this district. The termination process, and this is a true story. And unfortunately, everything I say here is going to be a true story. There once was a meeting where a teacher went to a Board of Education, and during a public comment site complained about her particular place in the school, mainly complaining about the school administration. After it was done, Board of Education members were saying, why are we still employing this person? You know, we should fire this person right now. That's not how it works. Frankly, for teachers, that's not how it works. We have a process where the superintendent of schools is responsible for making recommendations, considering termination of a teacher or non-renewal. The Board of Education will eventually decide whether to terminate or not. For example, if the superintendent of schools came forward with a recommendation, and after a termination period, the Board of Education decided not to terminate, that's happened before, this would not be terminated. However, the Board of Education can't initiate the process. Board of Education members can't say, I really hate Johnny Jones, that math teacher. I've been out with him for years. Why can't we get rid of him? You can't start that process. The process involves, we have a process in place with evaluations. I think you've probably heard about the word evaluation in the last couple of years. Once or twice. I mean, that's what happens is you develop it. I assume you have voted and you have the previous timelines for having a policy, a plan in place.
Yeah.
I don't want to say anything.
It's been approved by the state department.
Good. I mean, I've had a couple of clients where if I said that, I would be speaking out of turn. Do that. Congratulations. But the role is simple. You know, the superintendent of schools administration has a responsibility for administering and evaluating professional employees. Usually in the schools, and then we call them intermediate administration. They are responsible usually for the evaluation of the professional employees within their business. Superintendent of schools is the one employee that you will have to evaluate. In fact, all these obligations, administration, evaluation, teachers, superintendent of schools being evaluated by the board, these are statutory obligations. In fact, it is stressed now in the new evaluation statute. It's quite clear you're supposed to evaluate teachers on a yearly basis. And there's a consequence for not doing so. So that's the balance you have. Now, what are the problems people get into in terms of employment? And again, these are all true stories. Look, you have to sit eventually as a body that will determine, make decisions. You know, there's employee grievance procedures where eventually an employee may bring a grievance to the school. I'm not sure there's been many grievances over the years. Have there been many? We'll keep with that. That's cool. But you may have a termination case where a teacher termination case. And this board is to sit as an unbiased body. You have to. That's why you don't get involved in the nitty-gritty of, for example, I mentioned Johnny Jones and Matthew, because you may be called at some point in time, whether through a grievance, or through a termination process, to judge Johnny Jones. And if you've seen Johnny Jones' evaluations before a termination and come to it, let's put it this way, an informed decision, you're struck out because you're already a biased body. I once had a situation many years ago where there was a board chair, there was an employee got arrested for selling cocaine. And a member of a local newspaper called the board chair, and the board chair, we asked the board chair, what should happen? Well, we should fire the guy. You could imagine the teacher, when we had the hearing on the matter, was focusing on that statement. Now, fortunately, we were able to pull a rabbit out of our hat and say, what he meant to say was, if everything was true, we would consider firing him, and the judge bought that it actually was true. But the point is that you've got to refrain from making these statements, because these statements will come back and be used against you. Anything you say will be used against you by anyone defending the interest of an employee. You also sit here, I think you've had student expulsion. over the last couple. That's one of your jobs. I hate, unfortunately, the part of the board's job I see are usually the negative parts. I see the employee discipline parts. And I see when I'm involved with students, I'm not coming here to watch, Jimmy be honored. I'm coming here to see Jimmy be expelled. And you sit in the same powers. You set policy. You can decide by policy, there are certain things you must expel students for, and required by law. And there are certain processes you must follow. In your policy, you can enumerate, you can make a judgment decision as to what should be in there. I mean, most discipline policies through the state of Connecticut are pretty uniform, but you have some discretion in making those policies, except where you're required by law to expel someone. Again, when you sit as a Board of Education at an expulsion hearing, you're the jury. You have to sit here, listen impartially. We understand now that we live in small towns, and it's not possible for everyone to not know anybody like you have in a jury. You're going to know. However, the key is, can you judge the person based on the facts you hear? Now, if you've been involved somehow in that decision-making process, if you were involved with launching this parent or know something, you're probably going to be in a situation where you're not going to be able to sit on the Board of Education for expulsion. One area of the law that you will come into contact with is area of negotiations. Again, what I think is important, may not be really important, the most important thing is educating students, but the things I come in contact with are the negotiation process. And there's two basic types of negotiations, for teachers and administrators. I call it a nice orderly process with nice tight timelines. And also reporting, know where I'm going. And also there's a specific role, under the statute, the Board of Finance has a role in the teacher negotiation process, being able to meet and confer. For the other employees, we call the non-certified employees, there isn't such timelines. And unfortunately, those things can lag. In a just and proper world, there'd be stricter timelines in the non-certified negotiations. And it would also be, to be fair, there should be some consideration whether there is a role for boards of finances. Because right now there is no role for a board of finance to participate, to meet and confer, or to observe a negotiation for non-certified negotiations. And whether that's a wise thing or not a wise thing, that's for legislators to decide. But I know that's what they need to consider. Trying to explain the negotiation process in about 20 seconds is very difficult. As you know, there are different conditions of employment for the public sector versus the private sector. And I understand people sit around and wonder, well, gee, in the quote-unquote, people who raise real world private sector, there's a lot more, well, in terms of raises being lower, in terms of unemployment, things being different. The fact is, it is a different world. And what the statute's envisioned is that you compare, for the most part, the public sector employees to each other. The private sector, it's a different kettle of fish. And the fact is, the negotiation process, there's negotiations, there's a mediation process, which in some ways is, for those who have not gone through it, it's almost a case of trying to almost survive exhaustion, where you're often in a position where you'll be a mediation, literally 3 or 4 in the morning, trying to make tough decisions. In the perfect world, is that the way to decide things? Because probably not. Because you want to, in theory, be at your peak mentally and physically when making difficult decisions. However, the statutes envision a process where people will be forced under more difficult conditions to make these kind of decisions. And those who serve on the negotiations committee, I really tip your hat because you're now volunteering more for more than I do. Special education, I'll keep my words brief. There is a vast expanse of state and federal statutory framework for special education in terms of identification, finding children who have disabilities, and also providing appropriate public education in a particular environment. And the key to that process is what's called the planning and placement, which includes, administrators, special and regular education staff, special education staff. It does not include board members. The reason why I mention is this. These are a couple true stories. I once was sitting in my office one day, and I get a call from a special education director, who tells me, oh, by the way, we about to start a planning and placement team meeting, and guess who showed up? The chairman of the Board of Education. So that's interesting. Does it usually happen? The person wanted to be a mediating force. Look, there are specific people that this planning and placement team involves with certain expertise, and people that have right to bring applicants. Board of Education members should not be involved in, are not to be involved in special education decisions. I had a case many years ago where a parent brought a lawsuit because there was a planning and placement team who refused to make decisions unless the board ratified them. And that's not the way things are supposed to be. The planning and placement team is supposed to make the decisions based on the needs of the child. Now, this is another difficult circumstance where I had a situation where the parents of a student with disabilities who had a planning and placement team meeting. And the parents, well, it's the uncle of the kid, we'll say the aunt, disguised as identification. You guess it's aunt or uncle. Showed up at the PPT meeting. The aunt or uncle was a member of the Board of Education. That wasn't the most comfortable circumstance. We understand that, in a community, and this happens many times, where a Board of Education member is a parent, which that's a perspective that's very, very valuable. And it is possible that a special education, as a parent, as a Board of Education member, you don't stop being a parent. And no one's ever going to ask you to stop being a parent. And there may be times where you're a parent where you're having an issue with the Board of Education or not the Board of the district on a special education matter. We're not asking you to, forever surrender your right to speak for your child. I mean, you feel free to do so. However, that does place you in different circumstances. You've got to make sure we're careful and making sure a child of a parent, the child of a Board of Education member should be treated no better or no worse than any other student. And making sure that is the case, that no one is treated any different in that circumstance. The one thing you will see is that in area of special education is for discipline, the ability to discipline students who is requiring special education services is much greater and more limited than it is for a student who's not a special education student. And they wonder why that is the case. It's just a matter of federal and state law in court cases. Look, the Board of Education is a legal entity as a board. Individual board members have no legal authority on their own. You get nameplates, but you don't get badges. You're not allowed to go out in the community and say, here I have. I was there. Badges is Board of Education members. You can get your badges for another life. Unless you're a committee of one, unless somehow you're going to create a Board of Education, such as certain committees of one, a Board of Education member has no more right to make decisions on its own that will bind the school district than any other member of the community. The power belongs to the board as a whole, not any individual. Look, a Board of Education member has a right, and clearly should exercise their rights to raise questions and to propose actions. You're here to be vibrant participants, and you all are very vibrant participants. However, you should exercise authority you don't have, such as going to a teacher's classroom personally to observe a teacher's performance. Single-handedly trying to negotiate collective bargaining agreement on your